Joining us now, Slate senior writer Mark Joseph Stern, senior fellow at the American Immigration Council, Dara Lind, and former U.S. attorney and former senior FBI official Chuck Rosenberg. Chuck is also an MSNBC legal analyst. So, Chuck, I'm going to begin with you. It's been a while. It's nice to see you.
It's nice to see you.
Could you get a sense of where the justices were leaning today?
Well, there are two issues, right? So on the primary issue today, which wasn't birthright citizenship, it was on whether or not a lower federal district court judge can issue a nationwide injunction, essentially, right, affecting non-parties in other jurisdictions. I think the court was searching, right, for a way to be efficient, effective, fair, uniform, agile, because requiring plaintiffs in all 94 federal districts of the United States to file 94 separate lawsuits, to require everybody possibly affected to do that would be amazingly inefficient.
Yeah.
So I think they're trying to find a way to permit a single judge to bind the country, but perhaps to set some rules regarding when she may do that. And that's a hard thing to come up with. And of course, we grafted onto that today, Katie, the birthright citizenship case. But the first thing they have to figure out are the propriety of nationwide injunctions.
Mark, on that issue of the propriety, I think Sotomayor had a really interesting point, which is, you know, right now they're talking about birthright citizenship and the administration's mad over a nationwide injunction stopping that from happening. But she says, what if it's a president that comes in and unilaterally issues an executive order that revokes the right to own a gun and then demands that everybody in the country turn over their guns? It's an issue that you could see clearly in turning the tables, one that this administration, I don't think, would be in court arguing against. They wouldn't be saying, I don't want a nationwide injunction for that.
Yeah, that's the fundamental tension here, that sometimes the president or the government does something that is flagrantly illegal and also an emergency, and courts need to act quickly, and they need to act to protect the party's interest before them in full. And so if a future president tried to take away every citizen's guns and there were no nationwide injunctions available to courts, that would mean that every gun owner might have to run to court, get a lawyer, file a separate lawsuit and try to vindicate their rights individually. That cannot be a workable system of justice. And I think across the board, the court really recognized that. But the devil is in the details. And I don't think the justices were very clear on where the compromise here could come down. Even some of the liberals are hesitant about nationwide injunctions. Remember, these were slapped against the Biden administration throughout all 4 years of Joe Biden's presidency. These are a bipartisan problem to the extent they have proliferated. But then there are some cases where they're clearly appropriate. I think this is one of them. The coalition of states here is one of the plaintiff groups. 22 states have sued, saying that these birthright citizenship orders are illegal. If the Supreme Court says that there can't be a nationwide injunction here, that it has to be pruned back to just the named plaintiffs, then it would mean that there's birthright citizenship in 22 states and there isn't birthright citizenship in 28 states. So your citizenship would depend on what state you are born in. Again, that is not workable or practicable. And I don't think that the justices who are even most hostile to nationwide injunctions really have a good answer for how to solve that very serious problem in this case.
The problem is that this is also a modern issue. I mean, nationwide injunctions have only become a big issue in the last few administrations. And part of the reason is because there's so many more executive orders now.
That's exactly right. So before the 1960s, you really didn't see this at all.
Because Congress was functional.
Well, Congress was
more functional.
Was more functional than feckless,
yeah.
Absolutely. And executive orders were the exception and not the norm. And it's interesting, if you can trace the line of executive orders growing over the last several administrations, you can similarly trace a line of growing nationwide
It feels
injunctions.
like we are very heavily reliant on the courts to do a lot of the dirty work of governing right now.
Well, and that's right. And so this isn't, I don't think of this per se, Katie, as a dispute between Republicans and Democrats or liberals and Republicans, but rather between a president and the courts.
Yeah.
Sort of trying to find that right balance of power.
And a Congress that seems feckless, as you were saying.
I think that's a kind word.
Dara, let's talk about the merits of this case, because I do think we got some glimpses into how at least some of the justices feel. What did you see today?
Well, I mean, as Mark and Chuck mentioned, there's some discomfort about, on both wings of the court about the concept of a nationwide injunction. But that's why this is a particularly bad case for the administration to bring, because they haven't won a single victory in the lower courts on this. And the justices across the spectrum were very uncomfortable with the idea of allowing this to go forward. There were questions about whether the administration was prepared to implement this if they did lift the injunction. There were questions about the federalism issue, whether someone born in a different state would not be a citizen. These are things that they appear to be. It's rare to see the justices concerned with practicality and policy details at this level. And that suggests to me that as much dissent as there may be on the concept of a nationwide injunction, this is not a court that is particularly eager to uphold this executive order on the merits anytime soon.
It's a constitutional issue that has already been adjudicated by the Supreme Court 127 years ago. How could they go back on that? Is there an easy line to try to repeal that, Dara?
There's, in an originalist world, which is where, the thrust of jurisprudence has gone, it's not necessarily enough to say that the precedent has been set. You can say, well, that was a misinterpretation of what the people who wrote the constitutional amendment intended. And so the argument being brought before the court now is that the authors of the 14th Amendment did not intend to extend it to immigrants, and that the Supreme Court decided essentially incorrectly when it decided in Wong Kim Ark that someone could be a U.S. citizen even if their parents was a U.S. citizen by birth, even if their parents were not. It's radical, but that's not to say that it can't be done.